Greetings and welcome to an exciting new episode of PrivacyCast Season 3. I'm your host, Akarish Singh, and I'm delighted to have you back with us. As India embarks on our journey for a comprehensive data protection law, it's time to talk about it. In our quest going ahead, we called none other than Supratim Chakraborty, the partner at Khaitan and Co. And I think right now we're looking at a lot of guidance from Khaitan and also listening to him speak a lot in the industry about the Act. So, welcome, sir, and it's a pleasure to have you. Would you also like to do a short introduction about yourself?
Right. Thank you so much. I've been in this space for about 15 years plus, and people would be asking that how come there was no law? But there were laws around the globe, and in the Information Technology Act rules some of the things which the sector regulators threw. And pretty excited. Last 6 years have been another topsy-turvy journey. We are all aware. Have been kind of part and parcel of making of this particular law. It's been quite a journey. I'm very happy that finally it has fructified. And thank you so much, Akash and Sarut, for calling me here.
Yeah, I think welcome to our podcast. And our listeners love listening about technical stuff. They want to get more information. I think we don't have, I would say, our listeners like the YouTube influencers, but definitely all the people who are privacy experts, they're always listening to us and always giving us comments or, reaching out to me after that. So I know they would love this session today because today we're going to talk a lot about DPDPA implementation and also what is it that we need to do in coming days, right? So these are the two things that we'll definitely delve into. With your extensive experience in data protection, your insights would be incredibly valuable. So first question that everybody wants to know is, how do you compare Indian law, because as you said, you have been working around with GDPR and multiple others. Do you think that it is stringent enough, or do you think that maybe down the line the Supreme Court of India or other people will make things more stringent? Because right now we're looking at some consent requirements, some things around SDF. We don't have clarity on it. What's your thoughts on it, sir?
Right. So I think firstly, it's a great starting point. There are avenues to tweak it up or down. Okay. And we'll have to see how this is played out. What I understood from the mindset of the government is that there'll be enough amount of entrepreneurship and innovation which will be given impetus to. Okay. If the industry responsibly laps this law up, I don't think that this will be tightened to make it difficult or compliance heavy. It is at that juncture probably we will get to see stricter rules and requirements coming in.
Right. I'm just thinking that Aadhaar Act, which came out, and then something interesting happened. The Supreme Court, there was a case in Supreme Court. After that, whole world changed. And similarly, with Puttaswamy judgment, we as Indians already had privacy rights. I know very few people knew about it. And with IT Act also, if you remember, sir, IT Act also, we already had everything. Consent requirements, principles of privacy. But what do you think was the problem? Why these things could not be implemented, right? Because for Aadhaar, I get it, it was implemented, but for IT is already there, consent requirements are already there. Why do you think, what will change with this law?
Right. So I think I'll tell you, you're absolutely right that we had the Information Technology Act and the rules. Interestingly, if you see Section 43A, it says that damages are payable by way of compensation, and in a way it was uncapped. When GDPR came into effect, the organizations which had got some EU interface sat up suddenly and said, oh my God, 20 million euro or 4% of annual global turnover is quite a bit. Let's get prepared. Let's have our compliances in place. Interestingly, Indian laws always had it. I think the problem was with implementation. Okay, enforcing it correctly. That's number one. Because of the initial phase decisions, if you see by the adjudicating officers, penalties worth 5,000 rupees were meted out to a bank which had leaked sensitive personal data, right? So if you do that, you know where the law is headed. Interestingly, this is one point, Akash, I don't think any forum has ever discussed till now. I have not heard it anywhere. There is another section in the Information Technology Act, which is Section 72A, which is dealing with personal data. And it says that pursuant to providing of any service, if you have acquired personal data, then if you have disclosed it to someone against the consent of the person or in breach of a contract, then there could be imprisonment and then there is fine. That section, mind you, will remain even when DPDP Act comes into play. The deletion related provision does not have Section 72A mentioned. That's a parallel remedy of imprisonment which will continue.
It's very interesting. I think so. You just, all the data protection officers, guys, it's not the time to get scared, right? So it's not, nothing is gonna harm you, but but I think great point. I think I'm also learning, by the way, right? These are all the things, because a lot of times what happens is we are implementers, right? If you look at Saro, we are always implementing. We have built frameworks, and then going down the line. But when we look at case laws, right? If you look at a case law right now, I was in Europe 2 months back, and what happened is a case law happened against Meta, and then the consent requirement changed, because the case law said, with the final decision that came was that if Meta is going to process data, then again it has to reconsent from people to show specific ads. So those things, I think it's very difficult to first of all find online, because there's a lot of fact, right? Everybody posts a new article, new thing, and there is no solution to it, right? If I keep reading, sir, I obviously asking you also, what are these things that people can follow, our listeners can follow, where they can actually get some good information, right? Other than Saro, obviously, right? I will always vouch for ourselves.
No, I think, of course, in India, it is pretty nascent, and you will have to see what thinkers are talking about. I try to put up as much as possible online and also attend the sessions and all that. But do follow credible sources. My request is, sometimes I observe some clickbait articles being written, which is wrong, which does not have substance, which leads you to think in a very incorrect direction. Okay, so just try and follow those credible sources. I think it will lead you to good content and open up your thought processes. I'll give you one simple example, which you were talking about, Akash, that how things will evolve and develop. If you look at our this new law, DPDP Act, there is the provision in relation to consent, where they have talked about a very nice example, that there's a telemedicine app, and this lady has given consent for the telemedicine purposes, and also that app has taken consent for the entire phone book. That consent for the access to entire phone book is no consent. This auto expunging of consent, because it does not match up to the purpose, it's a very novel one for India to be written in this manner. Purpose limitation, we all know, right? Internationally also, we know that whatever you take consent for, it should have parity match up to the purpose. But this way to be called out, I think it's quite novel, and let's see how it plays out.
Yeah, I think down the line, and we talked about clickbait, so something came to my mind after listening to you for clickbait. So I think there is a fine of breach penalty, right? There's this breach penalty that is of 250 CR.
Yeah.
And that is something, I'll honestly tell you, I am a consultant, right? All my clients called me, and the first thing they said was, boss, 250 crore ki penalty lagegi here, right? And that kind of, that 250 CR is a big clickbait. But do you think it is a clickbait, or do you think it is coming in India?
No, I think it's about time that some of these are actually enforced strictly. So the number 250 that you see, you have to also keep in mind, we have decriminalized the law. It's not that there's no imprisonment provision. So, you cannot eat the cake and have it too and take one for home, right? So you'll have to understand that, where do we balance it out? Somewhere it has to really put a dent in order to make sure that there is compliance and people are really seriously looking into it. At the same time, I think if you look at the waterfall that they have talked about, the different parameters that they've talked about, as to when this could go up to that highest number, 250. And mind you, 250 is not the highest. Earlier, there was a cap of 500 crore, right? And that got removed. People got very happy. So therefore, the highest is 250. In a particular instance, you could actually trigger one or more of those items that are there in that list. That could mean 250 crore plus 200 crore plus 200 crore plus 100, 150 and 50. So all of that could come into play together. But there is a bit of a check and balance. And if you see basis what that can go up to the highest number of 250 crores, say, is that what's the nature, the gravity, the duration of the breach that we're talking about, okay? The repetitive nature, what was done to kind of mitigate the loss, what kind of impact can it have after the monetary penalty is imposed on an entity? So I think they have at least given the principles or thumb rules very clearly. It has to be now seen that how the rules further take it ahead, and also how the adjudicatory forums decide on these.
And I think next thing I definitely want to ask you, because I think you're the best person to ask this, honestly, because coming from a lawyer background and looking at all these laws, comparing all these laws, and something that very interestingly happens in Europe, sir, is we, as a human being, as a person in Europe, if I'm not happy with something, right, like a request, like a data subject, right, and I feel my rights are not being respected by a company, then I can go back and complain to a supervisory authority. When we look at India's parallel of that, so do you think that us as citizens should know about some rights and should know how to get those rights? Can you just enlighten us?
No, I think that has been embedded in the new law, actually, Akash. I mean, if you see, they are saying that your notice and consent, which are mandatorily to be sort of provided, those have to call these out. Like, what are the rights? How can you can get a remedy from the data protection board, and so on and so forth. So earlier, I don't think that a couple of these things were written, but I think this is a re-emphasis or clearly calling out that you have to tell this to the data principal or data subject, that these are the rights you have and this is how you exercise those rights.
And I think that is a great information that everybody is getting it, and people who are listening to us, if you're not privacy professional, this is important for you to know, right? Because from very soon you have, first of all, some rights, right? You have a right to forget. You have a right to change your data. You have a right to know what data the organization has. So please know these rights so that tomorrow, right, once the compliance deadline also hits the organization, right, you can go and complain against a company if you are getting unlimited spam calls, you're trying to get your data erased, but you're not able to do that. But again, some consent requirements and some data transfers internally between two companies, I feel like the law could have been better a bit around that, right, where data is being transferred among entities. So would you like to enlighten us there as well? Like, I saw, when I read the law text, I felt that maybe that inter-entity data transfer, how would that be affected after this law?
No, I think the data subject or data principal has the right to ask for that information, that who has my data, and that has to be provided. Okay, so it's not that it is not there. Okay, I see some articles which have been written. To my mind, I believe it is a little unfounded, concern. To my mind, the way it will play out is the necessary information will be provided to the data principals. At the same time, what we do not want is to lumber a lot of compliance on organizations. Again, please understand, the law is trying to balance data protection, personal rights, at the same time see that businesses do not go down, innovation does not suffer, entrepreneurship does not suffer. These are things which have to be looked at. India is at a very delicate stage, right? We have a amazing great growth trajectory. We don't want to shoot it down with additional compliance.
Definitely. When we also, a few of my friends were in Bangalore, and Mr. Rajiv Chandrasekhar was speaking, right? And one question that a fellow DPO asked, right, I got to read about it in one of the WhatsApp groups. He asked, there, that what is consent manager and what should the organizations know about this consent manager, right? Because since you talked about consent, I feel people, listening to us would be, more enlightened on the consent manager concept, and, will get the answer better, sir.
Right. I think so. We were kind of part and parcel of some of these initial discussions around consent manager. And see, the thought process was that India is a vast country, right? So many illiterate people speaking various languages, even the most educated people are not looking at what they are consenting for. We all have the consent fatigue, and we are just clicking I accept or I agree. So without being very legal about it, I'm talking in a very, very crude sense. What if I had a service provider to whom I give a power of attorney of sorts and say that, listen, I am okay to give consent for ABC, but I am not okay for giving consent to XYZ. So and that guy ensures that wherever your consent is going, it is in that fashion, that it is taking care of your diktat, the request that you have made. So consent manager actually is an entity which will be registered with the data protection board, and who will act as a single point of contact to enable that data subject to give, manage, review, withdraw consent through an accessible, transparent, and interoperable platform. So that's what they will do. I hope I've been able to explain simply to you.
Yeah, I think I feel like I think all the conversations that I have had around the industry, I think I was also very enlightened, and I think I learned a lot personally. And I know my listeners will definitely love this podcast, right? And would love to hear more from you. But I think one thing that I told you, like, that's gonna become a reel is that 200, 250 cr and 100 cr. So that is something that is very interesting, because people are people want to understand. And with other telecom sector laws, if you realize, telecom companies are actually getting penalized, right? It is not like they were not penalized. Governance was there, right? So why not with privacy law? We can expect it. Obviously not compliance burden, but definitely down the line. And sir, I have one bonus question, right? I know I have to ask you this for my listeners, right? If they want to become privacy professionals, right? If they want to become privacy, and especially privacy lawyers, right? Like yourself down the line. So what should they do today, right? That they can reach down the line in 3 years, 4 years, 6 years, whatever time they take. What should they do today, sir, to learn?
No, I think there
Feel
is
free to
no
say Saro Academy. Yeah, feel.
no, I think there is no substitute to training, sensitization, learning, and not only for the people who are listening to that in their organization and ecosystem. Till the last person on the floor is not educated in this space, it is of no use. Okay, I'll give you, Akarsh, two examples which I love giving. One, and both are hotel related. I was checking into one hotel, and there was a laptop which was kept, and the password of that laptop was written in a post-it and pasted right below the screen. And the hotel would have spent a lot on cyber security, data privacy, protection, whatever. But the last person on the floor does not know the importance of it. Then what's the fun?
Thank you, Supratim sir, for shedding light on DPDPB Act and its practical implementation. It was great talking to you, and I know all my listeners would love hearing you out. We hope to the listeners now, we hope you got some information, right? Please drop in some comments if we can do some improvement, we can change some topics you love. And stay tuned, we want to come down with the next episode very soon. And over to you, Supratim sir, for a quick thank you note to my listeners.
Yeah, thank you so much. Always very happy to speak with Adarsh. So whenever you guys need, I'll be there. Just give me a shout. Thank you.